Paper book volume, but kindly do not get influenced with the volume of the book. Math is very short, substantial questions so promulgated by the division bench are two in numbers. Whether the testament succession would prevail or interstate succession would prevail. These are the points of argument. I saw for partition, the trial court held dependent to be the owner in respect of the property on the basis of the
Yes.
Yes, start it.
Alati Rai Chaudhuri. Yes, you can start. No problem.
Now just wrong goes to the substantial question of first by the division bench. First order mechanism in lawsuit.
Yes, why?
First order in the first substantial question is formulated by the division bench.
Yes, yes. Why is that substantial? That order.
The orders.
Division bench order system বারপুর এখানে আছে আপনি তো এইখানে এই আছে order dated.
No, the order is dated by their lordship honorable justice Harish Tandon and Justice Rai Chaturvedi.
Yes, at the time of admission that has been.
Yes, bro. Two questions have been formulated. May I place it?
Whether both the yes, you can
Whether both the court below were justified in dismissing the suit filed by the appellant claiming declaration of right, title, and interest in respect of the suit property solely on the ground that the moment the will is executed in respect of the said property by a person is found to be genuine, it creates a title into a beneficiary of the legatee of the said will. That's the first question. Secondly, whether a probate granted in respect of a will has any impact on the right and title in respect of the property to which either of the testator or testatrix had a fraction of title or no title thereof.
So you are for the respondents. Now, what is the subject matter?
What has happened? My clients, the appellants herein, were the plaintiff.
Susuma Chakraborty and others. How many appellants are there?
There are two in numbers now.
Okay.
So they filed a suit for partition in simpliciter. Since they have inherited the suit land, they claim partition. The suit was resisted by the defendants who are the respondent herein, and a will was brought into to claim right title.
What is the relation between plaintiff and the respondent?
No, they are because
Malati Rai Chaudhuri is
Malati Rai Chaudhary is mother's sister, full blood sister.
This is mother's
Sister.
yes.
So, Lordship,
What happened? What is the subject matter of the suit?
so partition suit was filed.
Yes.
The trial court held that since the defendant is enjoying a will and right has been accrued in favor of the defendant based on a will.
Probate has been granted.
No. Probate has not been granted. My suit was dismissed. The title was conferred upon the defendants based on such will. First appeal was preferred under Order 41. It's an order of affirmation.
Yes.
But there are orders of our High Court which says that no probate is required in this island. But I would say, because the second question so formulated by the division bench goes to the root of the matter. Well, if any order, Manoj knows, if any order is passed in contrary to statute, it is to be labeled as judgment per inquiry. Everything has to be confined to the statute. The court can interpret the statute at best. So the second question has been formulated by the division bench while admitting the appeal.
Whether a probate granted will have any impact on the right title in case
My lord,
who is the either testator had fraction of title or no title there.
here the probate has not been granted in respect of the will, based on which the defendant claimed right title.
So why there is no stay order or something like that until probate matter is disposed of, that can be.
Yeah, probate is not mandatory.
No, that's, I'm coming, let me take the pen. Well, what I pray, the appeal itself can be taken up because Lord knows when a division bench has formulated this question, it's not a simply question of law. It's beyond that, substantial question of law.
I'm ready to hear.
My Lord, I'll just place it.
Okay.
I'll just place it.
So you are ready, sir?
Better. My Lord. Well, I'll just draw my Lord to the trial court's judgment.
Trial court judgment.
At page 132 of paper book. No, I'm just placing right from page 132, not page 133.
Yes.
The suit is for preliminary decree of partition, followed by division of properties by metes and bounds by final decree, partition, declaration, injunction. The instant suit valuing 4 lakhs and filed on 18/8/2009. This case record has been received by this court by way of a transfer from the learned civil judge, senior division, Port Blair on 13/12/11, and it was renumbered as TS 181 of 2011. The plaintiff's case, in short, is that the suit property details described in the schedule of the plaint originally belonged to the recorded tenant Tarapada Ray. He is our grandfather. This is grandfather. While Tarapada Ray, owning and possessing the same, he died leaving behind 2 daughters, namely Jayanto Chatterjee, that's the mother of the present appellant, and Malati Roy Chaudhary, who is there, for whom Mr. Anand appears. Defendant number 1 and his wife Surabala Roy, defendant number 2, who died during the pendency of the suit. Thereafter, Jayanto Chatterjee died leaving behind the plaintiffs, and plaintiffs inherited 1/6 share in the suit property. Plaintiffs and defendants have jointly enjoying the suit property before and after the death of Tarapada Roy. It is alleged that on and from 29/12/2008, the defendant is trying to alienate the suit property, ignoring the shares of plaintiff in the suit property, which led the plaintiff to lodge objection before the Tahsildar Port Blair. It is a further case of the plaintiff that on the basis of a forged will allegedly executed by Tarapada Rai in favor of Malati Rai Chaudhary, the defendant, she is denying right, title and interest of plaintiff for the suit property and has been threatening the plaintiff to transfer the suit property, which led plaintiff to file the instant suit. It is further alleged that no such alleged will has ever been executed by Tarapada Rai. Even at the time of execution of alleged will, his mental condition was not good and he was not in a fit state of mind, and as such, the alleged will is a false, fabricated and forged document. Feeling inconvenience to maintain joint possession with the defendants, plaintiff have filed the present suit for preliminary decree of partition, followed by division of properties by metes and bounds by final decree of partition, declaration, declaring the impugned will to be false, forged document, and declaring the plaintiff's 1/6 share in the suit property and recovery of khas possession of their 1/6 share in the suit property in injunction. The defendant entered appearance and filed WS denying each and every allegations of the plaintiff and stated inter alia that Tarapada Rai executed a will being number 39/05 dated 26/8/2005 and bequeathed the suit property in favor of defendant, and as such the plaintiffs have no right, title and interest in the suit property. It is further case of the defendant that the plaintiff did not look after Tarapada Rai and the defendant alone looked after him. Even in revenue case being number so and so, the plaintiff did not file any objection against the mutation in the name of defendant. According to the defendant, the instant suit has been filed on the false allegation and the suit should be dismissed. In order to prove the instant suit, the plaintiff have examined following witnesses: Sumitra Chakrabarti, Gopal Chatterjee, Shushma Chakrabarti, Malina Chakrabarti, Shrabani Chatterjee, Parul Haldar and Salman Khan. Only the authorization letter of PW7 has been marked as Exhibit 1. The defendant number 1 has examined following witnesses: DW1 Malati Roy Chaudhary, DW2 Amal Shuttar, DW3 Kanansh Bishwas, DW4 Rajesh Kumar. The defendant placed reliance upon the following exhibits: Exhibit A with objection, will dated 26/8/2005. Exhibit A1, A2, A3 with objection, signature of Tarapada Roy on the will dated 26/8/2005. Exhibit A4, signature of Amal Sutar on the will dated 26/8/2005. Exhibit A5, signature of Ranjit on the will dated 26/8/2005. Exhibit A6, signature of Rajesh Kumar on the will dated 26/8/2005. Exhibit B with objection, photographs of Malati Roy Chaudhary on the will dated 26/8/2005. Exhibit 6, original Patta passbook. Exhibit D, death certificate of Tarapada Roy. Exhibit E, death certificate of Surab Bala Roy Chaudhary. Exhibit F series, entire order sheets of Tahsildar in RC number so and so dated 16/3/2009 to 7/6/2010. Exhibit G series, paper publication under Form K by Tahsildar Port Blair dated 9/5/2009. Exhibit H, ration card of Tarapada Roy. Exhibit I, collectively identity cards of Tarapada Roy. Now, these issues were framed by the court at the appropriate stage. Is the suit maintainable in its present form and in law? Have the plaintiffs any cause of action to file the suit? Whether the plaintiff have any right title to the extent of 1/6 share in the suit property? Are the plaintiff entitled to get decree as prayed for? To what other relief, if any, is the plaintiff entitled to get under law? Lord would see none. These 5 issues where Lord knows the issues are framed based on pleadings. It's my concrete case made out in the plaint, and there is a prayer, corollary prayer, that the will has to be declared, the will has to be adjudged null and void. There is no issue framed by a trial court. But not, there are judgments of Supreme Court which says pleading and evidence are available on record even before pronouncement of judgment. The issues can be recasted. Lord knows it. Order 14 can be invoked. But there has to be a pleading, but there has to be evidence on record. Issue number 1 and 2 was taken by the trial court.
Why the matter has not been brought to the notice of the trial court at that time? That no issue has been framed. No issue has been framed on the relevant point that of the voidability of the will. You should have brought the matter to the notice of the.
We led evidence. We argued it. We led evidence. We argued. I'll draw monos to that.
Okay.
We led evidence. We argued it based on our plaint.
Yes.
But these two, issue number 1 and 2, my lord, I'm just skipping this issue number 1 and 2 because these 2 issues were decided in favor of plaintiffs as regards maintainability of the suit and the cause of action. The relevant issue would be issue number 3, 4, and 5, which start at page 137 at the bottom. All these issues being correlated and interlinked with each other are taken up together for easy discussion. The learned advocate for the defendant submitted that the admitted recorded owner of suit property named Tarapada Roy executed a will being number 39/05 Exhibit A and bequeathed the entire suit property to the defendant, his daughter, and as such there is no scope for the plaintiff to inherit the suit property on the date of testator, Tarapada Roy. The defendant has examined 2 attesting witnesses of the said will and the learned advocate who had prepared the said will, and the said will has been properly marked as Exhibit A. The said will is free from all suspicious and it is genuine one, and burden lies upon the defendant to prove that the said will and its execution and attestation has been fully discharged, whereas plaintiff could not prove their case and they could not establish any ground creating suspicious over the execution and attestation of will. According to learned advocate for the defendant, plaintiffs have failed to prove their case and the suit is liable to be dismissed. The learned advocate for the defendant raised objection and they submitted that the plaintiffs have categorically and specifically denied the execution, attestation of the impugned will. Just one second. I'm sorry, no. I'm so sorry. The learned advocate for the plaintiff raised objection and submitted that the plaintiffs have categorically and specifically denied the execution, attestation of the impugned will and have made out a case that Tarapada Roy was not a good physical condition and he was not in a fit state of mind at the time of execution of impugned will, and the said will is the product of forgery, and so the plaintiffs have sought for declaration declaring impugned deed to be false and fabricated one. The defendant did not file any additional WS denying the case made out by the plaintiffs in respect of impugned will. And as such, according to whom it is not being denied properly, it can be accepted as an admitted evidence. But what has happened? Initially, when the plaint was filed, there was no prayer with regard to the will to be null and void. By way of amendment under Order 6, Rule 17, these facts were brought in. But the defendant did not use additional written statement. And not knows Order 8, if there is no denial, it tantamounts to admission. Challenge has been thrown to the will on certain recognized ground, there is no denial. And not knows even this position, even defendant files a written statement, if the denial is not as specific, if it is an evasive denial, even then the court can say that it's admitted. Here, insofar as amended portion of plaint is concerned, wherein the challenge has been thrown to the alleged will, there is no additional pleading filed by the defendant. And applying the principle of doctrine of non-traverse, knows if there is no denial, to be more precise, specific denial. Simply denial will not do, Lord. They must justify that the manner and method, the circumstances under which the will was executed has to be pleaded.
During cross-examination, whether you have certainly in examination in chief, you have put all these things.
Yes, I will draw more to that.
And they have certainly they have denied
it.
Suggestion.
Yes.
Given. Okay.
So my first argument is, Lordship, as regards non-traverse, doctrine of non-traverse. Their conduct is hit by doctrine of non-traverse.
Yeah.
Look, at 138 bottom, with regard to this plea as taken by the plaintiff, this court has gone through the entire evidence and material on record and found that defendant in her written statement specifically stated that her father, Tarapada Ray, bequeathed the suit property in favor of defendant by executing a will being number 39/05, dated 26/8/2005. And as Tarapada Ray bequeathed his property, there is no chance of inheritance of suit property by plaintiff. On the basis of defense case, as made out in the written statement, the plaintiff took out an amendment wherein the plaintiff made out the case that the said will is vitiated by forgery. As the plaintiff's case of challenge against the will comes on the basis of a defense case, the defendant need not to deny the denial of execution of will. There can be no denial of denial. There can be no denial of denial. So this court finds no substance in the submission of learned advocate for the plaintiff. Lord, kindly see. Lord, suit is purely based on preponderance of probabilities. If I plead certain facts, there has to be pleading in rebuttal. If I lead evidence, there has to be evidence in rebuttal. The trial court holds that since the plea as regards existence of will was taken by the defendant in the original written statement, the doctrine of traverse will not be attracted. No, this is unknown to law, Lord, absolutely unknown to law. Particularly when defendant asserts right over the suit land based on alleged will. As I've said, my opening sentence of argument, my lord, whether intestate succession would follow or testamentary succession would follow. I say intestate succession. The other side claims testamentary succession based on the alleged will. This is the point of argument. Now, paragraph 18. Now, the learned advocate for the plaintiffs tried to convince this court and try to establish that the suspicious over the execution, attestation, genuineness of the impugned will. The learned advocate for the plaintiff pointed out from the impugned will that the impugned will did not contain any statement as to physical, mental condition of the testator at the time of alleged execution of the will. Tarapada Ray has another daughter named Jayanti Chatterjee who died leaving behind the plaintiffs. There is no whisper in the impugned deed as to why Tarapada Ray did not bequeath any portion of suit property to his granddaughters and grandsons plaintiffs. Now, this argument was advanced in view of the judgment of the Supreme Court, which says if a will is executed, my lord, it must within its folds say that who would enjoy the property and who would not. If any person is excluded, the reason must be assigned. The Supreme Court said if that be the case, then the will should not be accepted. There has to be recital in the will, my lord. Simpliciter excluding one person, giving the entire property to the other person will not make the will to be a genuine one. I will rely upon those judgments, my lordship. Then, my lord. 19. The learned advocate for the plaintiffs drawing attention of the court towards the date of presentation and execution of the impugned will, submitted that the will was allegedly executed on 26/8/2005, whereas the deed was presented for registration on 24/8/2005. Lord, I'm posing here. I'll draw laws to the very will. Lord knows under the Indian Registration Act, if any instrument is placed before the registering authority and when it is registered, execution date would be one, presentation date would be one, and registration date would be one. There would be a coincidence, Lordship. Presentation and registration date would be one and same. And even there would be a coincidence, execution, presentation, and registration would be one. But what happened here, Lord, kindly see, will was executed on 26/8/2005, my Lord. But it was presented for registration on 24/8/2005. How it could be, my Lord? And how the trial court dealt, I'll show, my Lord. How it was possible, he questioned. It is antedated one. And as such, according to him, the impugned will is false and forged one. He further contended that the date 26/8/2019 on the reverse side of the page 1 of the will has been interpolated and it was created suspicious about due execution of the impugned will. So according to him, by virtue of the impugned will, the defendant did not acquire any right, title and interest in the suit property, and in absence of it, the plaintiffs, being the legal heirs of Tarapada Roy, are entitled to inherit their shares, and the plaintiff have proved their case and the suit should be decreed. The learned advocate for the defendant further submitted that there is a special requirement to prove attestation of the will, and the onus to prove the will is on the date defendant, and the said proof should be to the satisfaction of a prudent man to come to a conclusion that the will is free from all suspicious circumstances and it is genuine. And in this perspective, he relied on the case law reported in 2005 volume 2 SEC 784 Sridevi and others versus Jairaj Shetty, and 2010 volume 5 Supreme Court cases 274 SR Srinivasan and others versus Padmavata. The Honorable Supreme Court held in 2005 volume 2 SEC 784 that it is settled proposition of law that mode of proving the will does not differ from that of proving any other document except as to the special requirement of attestation prescribed in the case of will by section 63 of Indian Succession Act 1925. The onus to prove the will is on the propounder, and in absence of suspicious circumstances surrounding the execution of the will, the proof of testamentary capacity and the proof of signature of the testator as required by law need to be sufficient to discharge the onus. Where there are suspicious circumstances, the onus would again be on the propounder to explain them to the satisfaction of the court below. The will can be accepted as genuine. Proof in either case cannot be mathematically precise and certain and should be one of the satisfaction of a prudent mind in such a matter. In case the person contesting the will alleges undue influence, fraud or coercion, the onus will be on him to prove the same. As to what are the suspicious circumstances have to be judged in the facts and circumstances of each particular case. The propounder of the will has to show that the will was signed by the testator, that he was at the relevant time in sound disposing state of mind, that he understood the nature and effect of disposition and had put his signature to the testament of his own free will, and that he had signed it in the presence of two witnesses who attested in his presence and in presence of each other. Once these elements are established, the onus which rests on the propounder is discharged. Well, I'm just pausing for a moment, my lord. Will has to be proved by examining one of the attesting witness. Evidence Act is clear. Now, this term attestation, my lord would find in TP Act. Now, attestation is not a simply idle formality. Either in the will, one of the witnesses have to certify at the foot that he found the person who making the will, understanding the contents. After understanding it, he signed it. In his presence, the attesting witness have signed it along with the others. There has to be an attestation in the body of the will. It's not a mere formality, my lord. Simply saying in the evidence that it was attested will not do. Attestation has a different connotation, particularly if it is a case of will. Because one would claim right on the basis of will by scuttling the right of the other. Here is a case where my rights have been scuttled down. It has been held in 2010. I'm proceeding further at page 141, Lord. Yes. 5 SCC 274, that since section 63 of Succession Act requires a will to be attested, It cannot be used as evidence until, as required under Section 68 of Evidence Act, one attesting witness at least has been called for the purpose of its execution. If there been an attesting witness alive and subject to the process of the court and the capable of giving evidence, unlike other documents, the will speaks from the death of the testator, and therefore the maker of the will is never available for deposing as to the circumstances in which the will came to be executed. This aspect introduces an element of solemnity in the decision of the question whether the document propounded is proved to be the last will and the testament of the testator. Normally, the onus which lies on the propounder can be taken to be discharged on proof of essential facts which go into the making of the will. Cases in which the execution of will is surrounded by suspicious circumstances stand on a different footing. A shaky signature, a feeble mind, a unfair and unjust disposition of property, the propounder himself taking a leading part in making of the will, under which he receives a substantial benefit, and such other circumstances raise suspicious about the execution of the will. That suspicious cannot be removed by mere assertion of propounder that the will bears the signature of the testator, or that the testator was in a sound and a disposing state of mind and memory at the time when the will was made, or that those like the wife and children of the testator who normally receive their due shares in their estate were disinherited because the testator might have his own reasons for excluding them. The presence of suspicious circumstances makes the initial onus heavier, and therefore in cases where the circumstances attended upon the execution of will excites the suspicions of court, the propounder must remove all legitimate suspicions before the document can be accepted as last will of the testator. It is in connection with this will, the execution of which is surrounded by suspicious circumstances, that the test of satisfaction of the judicial conscience has been evolved. That test emphasizes that in determining the question as to whether an instrument produced before the court is the last will of the testator, the court is called upon to decide the solemn question, and by reason of suspicious circumstances, the court has to be satisfied fully with the will has been validly executed by the testator. This court had heard both learned advocates appearing for the respective parties and perused the entire evidence on record. Admittedly, the suit property originally belonged to Tarapada Roy. This suit is a balancing one. If will stood, the plaintiff suit will be dismissed, and if will is found to be a forged one, the plaintiff suit will be decreed. The above mentioned citation makes it clear that the propounder of the will, that is the defendant, must prove execution, attestation, genuineness of the will, and remove all suspicions surrounding the will. Let's see the oral and documentary evidence on record in this regard. It is pointed out that the reverse side, now this is a finding of the trial court as regards the date of presentation and the date of registration. This is the adjudication made, a wrong adjudication, Lordship. It is pointed out that the reverse side of first page of the will recorded that the date of presentation of will as 24/8/2005, whereas the execution was done on 26/8/2005, and in one place of the said page the date 26/8/2006 was overwritten. But it is to be remembered that the reverse side of the first page of the registered document remained in the domain of registry office, and the entire reading of the reverse page revealed that there is no fault on the part of concerned registrar to put the date and to overwrite date 26/8/2005. On the same page at the bottom, the registrar was given a correct date, that is 26/8/2005. So for the fault on the part of registrar, the party should not be suffered. So whatever mistake as to putting of wrong date is, that is 24/8/2004, or overwritten the date, that is 26/8/2004, do not create good ground itself to declare the will as forged document. Moreover, the PW7 Salman Khan was attached to the sub-registrar office, Port Blair, and he brought the certificate copy of the will. And so there was a chance of comparison of original with the certified copy, but nothing was pointed out to him as to such alleged interpolation of the date or about mismatching of the date of presentation of the will and the execution of the will. The plaintiffs could have brought the facts to the notice of witnesses, PW7, and the witnesses could enlighten it, and so the situation remain unexplained before the court by the staff of registry office, PW7. In absence of such explanation, the document is to be interpreted by applying judicial conscience. So the plaintiffs are not entitled to get any benefit to such mistake done by the registry office. So the submission of the learned advocate for the plaintiff in this behalf is not convincing. But I'm pausing here, Lordship. I will draw my lords to the will. Lord, the trial court held the dates to be a minor slipshod. The trial court records that it's a purely a mistake. This can't be. Not kindly, not man may lie, not, but the document may not. Not kindly see the alleged will. I'll draw my lords to that. The alleged will. It's a part of the paper. I'll just show that. My lord kindly turns to page 96. My lord, as I've said, my lord, execution date may be a different date. Presentation date may be a different date. Registration date may be different. But it may be a coincidence. All these three things can be done on a particular date also. But that is not the case here. Now kindly see page 96. That's the alleged will. And my lord, see page 97. Page 97, my lord would see the seal of the registering authority.
This is the last two. That's one page will. One page will.
It's a 1, 2,
Oh, sorry.
3.
Yes.
Because in every reverse side of the first page of the will, there are endorsement of the registering authority. See page 97. Because page 97 is the reverse side of page 96. I have paginated, I have rather put in the paper book as a different page. And my lord would see the lower court record auto itself also arrived. My lord, see page 97.
Yes.
My lord, I'll just show the date of alleged execution. Page 98 may kindly be seen. Page 98, my lord, alleged execution. 98 and 100. My lord would see, I have executed this will on this day of August 26, 2005. And my lord, compare this with page 100 also. Page 100, because the scribe, being an advocate of this wife, have prepared it. This was the case of defense. My lord would see, just in the scribe certificate, my lord would find 26 August 2005. There is no attestation in the entire body of the will, which is a mandate of law. I'll argue on that with reference to judgments. My lord would see the dates. I'm on dates. It's not so easy, my lord. It can't be a clerical error. It can't be. And my lord now kindly turns to page 97. Now this, the burden was heavy upon the defendant to dispel this anomaly. It's not upon my client. I have examined my witness. I have shown that the suit land is an ancestral property. I have brought the will. It is the burden, primary onus I have discharged. Now it is the defendant, because the right has been conferred to the defendant by the trial court.
How you have discharged your onus?
Onus by bringing this will, my lord, and no, that's what I said.
You have said that that the testator was not fit at the relevant point of time.
Yes.
Have you brought any document to that effect?
I'll come to that. But this first point is
How much time you will take?
it will second appeal. Every evidence have, because second two questions.
Again tomorrow. Yes, I think 10 minutes.
I would refer, because the scope of second appeal is very limited.
Yes.
Few material evidence I'll show, and how the. Now I can continue tomorrow also.
Okay.
Tomorrow.
Please,
Let it be treated as a part head, my lord.
Why?
Because otherwise it would go down. It would go down. If my lord,
you have to assure me that you will complete by tomorrow.
Yes. So far as I'm concerned.
The point of law and the document.
Yes.
And another thing, Mr. Joypal, another thing is that I have heard that no form is required for the purpose of making a will.
Absolutely.
No form.
Registration is not required.
Whether I shall place myself in the armchair of testator.
Absolutely.
More technicality is required.
No, he's a senior counsel, and you are also. Okay, and I am junior.
No, certainly not.
First time in circuit.
Certainly not. But my lord's past experience, my lordship, we are junior, my lordship.
The learned counsel for the appellant has commenced his submission but does not want to stop. The learned counsel for the respondent, respondent is also present. Stop. List the matter or I'll give it to you.
As part and blood.
as part.
Yes, I'm grateful. And
You have to complete.
yes.
Both of.
By all means, by all
So
means.
that I can get time.
By under how much time?
No, my lord has given tomorrow's time. By tomorrow will complete.
Yes, no problem.
By all means.
পাঠার বলে লিখে রেখে হ্যাঁ পাঠার হিয়ারিং ফার্স্টেই দিয়ে দেবেন
Right.
ফার্স্টে দু চারটে পরে দেবেন কারণ অন্যগুলো তো বসে থাকে হ্যাঁ পাঠার থাকবে সেটা অ্যাডজাস্ট করে দেবো হিয়ারিং
Obliged.
Lordship, my senior applies for the petition.
No, yes. You are for the petition.
Petition. Lordship, I have been informed that private respondent would take time.
But
An adjournment.
he did not come. Information.
Lordship, in item number 3, I am for the private respondent. Lordship, my difficulty is that due to cold, my throat is infected and right ear is
So
blocked.
let her complete, then I shall. Okay,
Let it be.
you please take down notes. Yes, what is the matter? You have
Let
told me
short pass on my senior will be doing the job.
you're senior.
Lordship.
Okay. That's what, for the timing, Mr. Kormakar.
That matters.
Lordship.
Here case registered cognizance taken, someone issue that happens.
Okay, whatever.
Lordship, I pray that let the matter be on Monday so that I
Why?
can assist this honorable court.
No,
I am ready to assist Lordship.
if I need so. If I need your assistance, I certainly, but we are under pressure to dispose of certain matters, okay?
Lordship,
I can grant you time tomorrow you please
day
come,
after tomorrow on Friday, Lordship.
Friday.
Friday.
Where is your senior?
He's on his legs before.
Then she will come and she will say that some urgent matter, then. So we can finish their submission, then we can.
Let Friday, Lordship.
On Friday, Lordship, I will assist.
Not today then, only I can give you not today.
Lordship, because of the serious infection.
Take
cold
some
infection.
gargles, hot water.
Lordship, my right ear is blocked, Lordship. That is the difficulty. So I pray, let it be on Friday. In the meantime, I will.
Okay. The learned counsel for the respondent,
Private respondent.
private respondent has sought for an accommodation. Stop. The learned counsel for the petitioner and these respondent number 1 state
Six.
are present. Stop. Please the matter on Friday করে দিন হ্যাঁ ঠিক আছে
Obliged.
এইটা কি দেখুন তো, এটাকে আগেরটা নাকি আগে এটা প্রিভিয়াস ওয়ান আই থিংক ইউ আন্ডারস্ট্যান্ড এভরি ঠিক আছে সরি
Lordship, generally I used to appear on behalf of the electricity department, Lordship. I believe my senior has served the department, but I have not received. the copy. Let it be not today, Lordship, tomorrow I will.
I don't have for respondent number 3 and 4. I shall be using affidavit in opposition of mine. Yes, my lord.
So have you got the copy?
Yes, my lord. Copy has been served.
So you have to file this day after tomorrow, okay? Affidavit in opposition.
Yes, my lord. I need 2 weeks.
What is your you have filed this writ petition and he wants to she wants to file.
She is the private respondent, Lordship. I am appearing for the official respondent.
So why it is needed?
Yes, your honor, because there is a civil dispute. It's a family dispute. So, and the respondent number 3, being the father of the petitioner, he has filed a case, civil case for the eviction of the petitioner in civil court.
In respect to some other property, not
And-
this property.
What
Yes,
can be
sir.
done, sir? A
This
Ligunator,
is another property.
the learned counsel for the respondent number 1 and respondent number 2.
Respondent number 1 and 2.
Do you want to file any affidavit in opposition?
If liberty is granted, I will be also. using
Respondent
that.
number 1 and respondent number 2. The learned counsel for the respondent number 2 wants to file an affidavit in opposition. Stop. The respondents number 1 and 2 are given liberty to file affidavit in opposition by Friday.
Lordship, it is not possible. I am appearing for the government officer, Lordship. There is certain procedure because
So-
it has to go up to the secretary level and
So
thereafter. after meeting.
you are at liberty. You are at liberty. You may not file.
I am appearing for 1 and 2 private respondent. They are praying, Lordship, because I don't have any objection. If this court will direct me, I will provide the electricity
So,
connection.
sir, no, sir, respondent number 1 category, the respondent number 2 is to file the affidavit.
I am appearing for 1 and 2, Lordship.
And he is appearing for
3 and 4.
3 and 4. That is the problem. Respondent number 3 and 4. পুরোটাই হবে প্রথমে যেটা লাইনটা হয়েছে respondent number 3 and 4 হবে হ্যাঁ The landed council for the respondent number 3 evidently opposition is pending by private police.
2 weeks time.
Why?
Just for making a.
I do not know. I had to go through the law and I shall pass order. The fast track court. Okay. For YOLO, by Friday. Okay. Let the matter appear on Monday. Okay. The point of law only. Point of law only. You are saying.
Because I will.
Okay.
Milord, I am for the respondent, Milord, respondent plaintiff in the suit.
Lordship, in this matter,
Please step the chule gachi. Yes, please.
Yes, Milord, I am the respondent plaintiff, Milord, in the present civil tribunal application, Milord.
this
Milord, I have a small submission before your Lordship, Milord. I have another matter on my Lord on 9th April. Milord, I want to do this matter, my Lord, physically, Milord. Your Lordship.
Why virtual hearing has been commenced because for your benefit, wherever you are.
No, Milord, not for this matter.
Let us hear what is the submission of
Lordship,
the
in this matter,
petitioner.
learned senior counsel Satadhu sir is appearing for the petitioner.
Yes. Where is Mr. Chakraborty?
Your Lordship, he is not in station. Let it be in the next week. Your Lordship, he'll be here.
No. Why he is not in the
Due to some personal
No,
difficulty,
why
he is not.
personal? And we have left our family and come back here and have come to this circuit after leaving my family, personal problem. In the mainland, we have come. No. What is this matter? Who is for
My
the?
Lord, may I just indicate, my Lord, this is suit filed by me, my Lord, seeking that I am entitled to a grant issued in my favor by the administration, my Lord. It's a statutory grant. What had happened in 2014, the administration, my Lord, did not renew the grant. Whereas my case is, as per the regulation, I have there is a statutory rules whereby I am entitled to a further period of 30 years, like period. So, in that issue, my Lord, suit is pending before the learned trial court. The learned trial court granted injunction, my Lord, in my favor. After considering that I am in possession of the property, and there are other orders passed by the High Court as well, where protections were given in my favor. They challenged the injunction order, my Lord, before the district judge. The district judge, my Lord, has also practically affirmed the judgment, only modify the injunction order to the extent to maintain status quo. And as per the record, I am in possession of the property. Now, against the order of the district judge, they have filed a civil divisional application, my Lord. And after filing the civil divisional application, my Lord, they have also filed an application for rejection of claim before the suit court. That application, my Lord, is fixed for hearing, my Lord, on 9th April 2025. So that I have to attend physically. That is why, my Lord, I was requesting if your Lordship may keep this matter on 9th January so that I can appear physically before your Lordship. That is the whole issue.
A matter of 2022 and
Lordship, I'm
Yes,
just,
yes, 2022. Yes.
Proxy,
Your Lordship.
college tab, proxy for your friends. Okay. So it's a very simple matter, I think.
Yes, it's a very simple matter, my lord. There are others orders also, my lord,
Your-
passed by High Court, my lord, in the constitutional writ jurisdiction, my lord, where the protection is given in my favor.
The learned counsel for the petitioner and also the learned counsel for the respondents have sought for an,
Respondent, my lord, only respondent, plaintiff.
you're for the respondents here.
Andaman plantation, my lord, plaintiff, respondent.
The respondent number one, for example.
Yes.
Number one. Have sought for an accommodation. Stop. This is the matter of mind. This is the matter.
Grateful,
Of life.
grateful,
Nine.
grateful.
Item number 6, right?
Yeah, আমি দেখতে পাই না আচ্ছা আমি Mr. I cannot see the list or something like that. But where is the number? এখানে this one. I have to see this. In our inland, that is. Yes.
Your Lordship, this is the second appeal, Your Lordship. Here, the
So you are ready. What is the law points?
basic law point is that, Your Lordship, when the defendants have raised a specific plea of limitation, waiver and acquiescence,
So you are for the plaintiff.
defendant,
You are defendant in the trial court.
no, plaintiff,
Plaintiff in the trial court.
and just a minute, defendants,
The
I'm sorry,
defendant-
defendants,
And you are for the plaintiff.
plaintiff,
What is the suit about?
partition suit.
Yes. Now, why?
They have claimed partition in respect of a property which was recorded in the name of the father of their means one Suren Das. Suren Das was the original owner of the suit property, and these plaintiffs and defendants are the legal heirs of Suren Das. They filed a suit for partition. Now, in the written statement, I have specifically pleaded in my written statement that there was a settlement in the family, and pursuant to the said settlement, the plaintiffs, the defendants, not plaintiffs have released their share in favor of the defendants, and that settlement was finally decided by the Tehsildar while mutating the property in the name of the defendants around 15 to 20 years ago. And they have rendered their no objection before the Tehsildar on the basis of which mutation has taken place. And I have also stated that on the basis of that mutation, the land was recorded in the name of the person concerned, and he has borrowed loan from the bank where one of the witnesses was the plaintiff. So I have specifically urged in my written statement about the plea of waiver and acquiescence, as well as the plea of limitation. That particular, none of the plea which I have raised has been made as an issue by both the courts and adjudicated by both the courts. So I have preferred the second appeal, and the question which was framed by this honorable court, Your Lordship may kindly come to that question.
The order sheet গুলো কোথায়?
173, paper book 173. It is there, part of the paper book.
73.
Yes.
Yes.
Have the trial court and the appellate court erred in law in disposing of the suit and the appeal respectively without taking into consideration the issue of limitation raised by the appellant in both the suit and the appeal? This is the question.
Only one question.
Only one question, because Your
Only
Lordship,
one question.
yes, when I have raised a point of limitation, waiver and acquiescence, whether the trial court was not supposed to frame that question, Your Lordship, because that is the defense which I am taking
No.
it.
No. There's a very short point.
Very short point is
Very
there.
short point.
Now, Your Lordship, may I place the
Jasmine,
judgment, this.
So now my first question, whether this type of release can be done without executing a deed of documents?
Family settlement is not required to be registered. Family settlement can be done in any manner. Any manner, Your Lordship. I will place judgments. I will pay. Family settlement can be done in any manner. Now, pursuant to that family settlement only, they have submitted their no objection before the Tehsildar. On the basis of the no objection, mutation has been done in my favor in 1985.
So we have to consider the limitation point here.
Limitation.
Limitation. Now the question will certainly come whether this type of release can be made by way of family settlement or
All
not.
these things will
That
be
has to be looked into.
looked into.
Yes.
That's what, Your Lordship, I am submitting. I will be specifying those paragraphs. Your Lordship may kindly come to, because we have a regulation also. And under the regulation, Your Lordship, what is recorded in the record of rights, that is considered to be the perfect title, Your Lordship.
So
Unless and until that is
in our mainland, it is not.
that is
The only document of possession.
Yes, here, Your Lordship.
Here is a document of title. Is there any judicial decision on that aspect, that in Andaman Nicobar Islands, that record of rights is regarded as the document of title, not document of possession? Is there any judicial
Your Lordship,
decision?
here the thing is that all the persons in these islands are licensee. They are not the owner. Owner is the government. But in the regulation itself, it is mentioned that whatever is recorded in the record of rights, unless and until that has been set aside in accordance with the regulation, that will be considered as the settled thing.
Okay.
It is there in the regulation itself. I will
Okay.
place all those things. I will place, Your Lordship, one by one.
No problem. Yes.
So, under such circumstances, when the mutation took place in the record of rights, now my name was incorporated. Under regulation 204, Your Lordship, the remedy which is provided under the regulation, for that, Your Lordship, no civil suit is maintainable itself. No civil suit is maintainable. Now, this particular mutation happened in 1985. I have specifically mentioned. And the suit was filed in 2000. Just a minute. Yes. In December 2000, the suit was filed. I have stated, Your Lordship, in certain paragraphs I wanted to refer to. Paragraph 8. Your Lordship may kindly come to paragraph 8.
So that issue was not framed.
Not framed, Your Lordship. My written
But whether the suit is maintainable or not, that issue is there, I think. Whether the suit is maintainable in law or in facts, the first issue must be there. Maintainable in law means limitation.
Yes, yes, Lord, just a
Issue
minute.
limitation act can.
Issue separately, it is there.
What is the issue? At least from
Your
judgment.
Lordship, maintainable and limitation are two different things, Your Lordship, because maintainability of the suit is with regard to the whether the suit itself can be entertained or not.
When the division bench has framed the substantial question of law, then we have to.
Yes.
Is the suit maintainable in its present form in any law? 127. From judgment,
Yes.
I am.
Yes, Your Lordship. Page number 32 is also. Page number 32 also questions are there.
Is the suit maintained in its present form and in law? Okay. And in that discussion, he did not mention the limitation point.
No.
That is the main thing.
And even in the judgment also, Your Lordship, I will refer to the judgment. Even in the judgment, that is not taken into consideration.
Yes. So this is the point.
So I have to place, Your Lordship, one by one the paragraphs and everything, Your Lordship, so as to establish that I have taken those specific points and how the same has been dealt with the learned trial court as well as by the appellate court. Those will be referring, Your Lordship. May
So today you are ready.
I think we
can continue. No problem, because there are other matters also.
We can continue tomorrow, Your Lordship.
Yes, tomorrow.
Tomorrow.
Yes. So this is a very short point. So what is your submission, sir? Just
limitation point has been considered by the trial court as well as appellate court.
Okay.
And after giving that partition suit is a partition suit.
Yes.
There is no question of any limitation, because one co-sharer is possession in other co-sharer, right?
That is true, but she is saying that the accusations.
Yes.
She is taking the plea of accusations
Yes.
that his or her name has been mutated
Yes.
and there is no.
In 1961, Supreme Court already decided the court of right does not create any title in favor of the, it's only for document of possession. Have you placed that judgment?
That is true, but here there is some regulation.
Regulation. I will place the regulation. I'll
So
place
these
the
are very short points.
Very short
You will
point,
take
sir.
10 to 15 minutes, I think. Oh,
I will be referring, for referring, your lordship,
oh,
time.
7 minutes, very good.
So not 7 minutes. Argument, I will,
So,
argument
this
will
is-
take time, 10 minutes, but referring documents, your lordship, it
Okay,
will
okay.
take some time.
During mutation proceedings, submitting the objection, there is nothing
Okay.
until the which deed is registered by the parties.
Okay, very good. No, the learned counsel for the appellant has commenced her submission but does not conclude. Stop. Please the matter tomorrow, buttered.
Your lordship.
Buttered.
Okay.
Yes.
Lordship, in this matter also learned senior counsel Satadru sir is appearing. Can it be in the next week?
Yes, they're ready.
But it's for,
Yes. Why this matter has
one of the defendant was not served.
no, the names of legals have been furnished in court today. Yes, what is your submission?
Lordship, learned senior counsel Satadru Chakravarti sir is appearing.
The learned counsel for the appellant or petitioner has sought for an accommodation. Stop. This the matter on 7th. ঠিক আছে?
Obliged.
Next. এই আবার লিস্টে চলে গেল ভুল করে বারবার দিয়ে আছে এটা এইদিকে রাখি ঠিক আছে
This is another second appeal. Item number 8, I am agreeing for the appellate. Item number 9.
My senior appears for the petition. Appellant.
Arising out of same judgment and
so she's not ready.
Can it be
So
on
not
Monday?
today. Not today.
let it be on Monday.
Let it be on Monday.
Tomorrow, there are another two.
No. Yes.
Let it go Monday. Monday.
The learned counsels of the parties have sought for an accommodation. Stop. This is the matter on Monday.
Obliged.
Your lordship, I am for the appellant, your lordship. Second appeal, your lordship.
Who is for the other side? Not today then. Not. Oh, here. What is the substantial question of law?
Your lordship, the main thing is that, your lordship, there is a difference between West Bengal Tenancy Act and the rent control regulation which is prevailing in these islands. The difference is that, your lordship, so far as the West Bengal Tenancy Act is concerned, for a tenant, in order to evict a tenant, the grounds which are mentioned with relating to bona fide requirement, it also says that if the landlord has any other place to reside,
Hmm.
and he is deliberately not residing in that place and wants to evict the tenant, then he cannot, that cannot be considered as a bona fide
If he
requirement
has reasonable accommodation elsewhere.
elsewhere. That
Reasonable,
was-
suitable accommodation elsewhere. If it is not suitable, then he can.
That particular thing is absent in our regulation.
Okay. So come back on when?
Monday, your lordship.
Monday.
No, your lordship, as subject to your lordship, because two appeals are there tomorrow. That is
Oh,
the reason,
Friday?
right?
Please come. Friday. We said, but it is not part of
Your lordship.
chicken. Friday package. ঠিক আছে? Hey, Mr. Olu. Yes.
Okay, are.
11.
Yes, Your Lordship. I am for the appellant, Your Lordship.
And who is for the other side? Ready? Yes, what is the case? Will be.
Section, it is related to the motor accident created level and it's an appeal has been prepared and section, it is fixed for the hearing of the section 5.
Section 5. So, how much delay?
2 years, Your Lordship.
2 years.
Your Lordship. MSCT, Your Lordship.
Oh, is it about 55 years?
Illiterate lady, Your Lordship.
Your Honor, I have strong objection as.
But have you filed any opposition? Have you filed any opposition?
No,
So your oral submission.
yes. I'll be producing the judgment, Your Honor.
So file an affidavit in opposition. Then I have to deal with your opposition. The learned counsel for the respondent wants to file an affidavit in opposition against the petition under section 5 of the Limitation Act. Stop. When you will file?
Next time, maybe.
Now. No, come back on Monday. Please the matter on Monday. The respondent number is given liberty to file affidavit in opposition, if any. By 7th. Please the matter on 8th. Okay.
You can see this. Esa marca.
If you are not able to file, then we shall take up and we shall consider your oral submission on 8th. Okay, no problem.
It's 8 of 124.
Your Lordship, I am for the
We have filed our.
Your honor. Who is your honor?
Apologies, unconditional apologies. My lord, I have filed my wakalat, seeking for an accommodation to prepare the matter. We have just received the paper book and we need to assist the matter.
So how much time you want?
My lord, we are praying for the next circuit.
No, success. You are a young man.
Would be a
Yes.
senior, my lord.
Yes, whatever, please come back on Monday,
In that case,
Monday?
next Wednesday, my lord, Wednesday.
Wednesday.
We have already, before my lord, we have matters on.
Judgment of reversal, Your Lordship.
We have matters.
You are appealing for the respondent, no? All the respondents.
All 3 respondents.
The learned counsel for the respondents. You remain absent for number of occasions.
My lord, on the last circuit, we were unable to find wakalat and.
The learned counsel for the respondents has sought for an accommodation. Stop. The learned counsel of the appellant is present. Please the matter on with. Next. Wednesday.
Correct, my lord.
That means okay. 9th, no? Our feeling now. Our feeling now.
Ground same grounds, lordship. No infections. And for the respondent, lordship, they to fix on Monday, lordship.
The learned counsel for the respondent. For the respondent. That's short for an accommodation due to his ill health. Stop. This is the matter on Monday.
Okay.
Your Lordship, I am for the appellant, Your Lordship.
Respondent number 1.
Yes, sir. What is this?
This is suit for specific performance was filed, Your Lordship. So may I, Your Lordship, may I begin, Your Lordship?
Suits for specific performance.
Your Lordship.
This is also second appeal.
Second appeal, Your Lordship.
No, I have finished all two second appeal first, then come back on Monday,
Monday,
we shall try if
Your Lordship.
we are able to. Next, Monday. Huh.
25.
My lord, in item 15 to 22, my lord, I said Mr. W appear for the petition, my lord. He is not in station due to some personal reason, my lord. So I'm praying for in the next week, my lord.
The learned counsel for the petitioner has sought for an accommodation. So there are eight number of cases.
8 numbers.
So
my lord.
family, there are family matters, I think. Who is
No,
for the
no, my
CBI?
lord. It's a CBI case. my lord.
Sundarbha, there are eight
It's a-
cases.
It's a CBI Prevention of Corruption Act. Okay.
So it's a very serious issue.
Madam, sir, we have praying for passing of affair. In 2018, one affair was chalked, and due to some on the same set of action again, affair was lost.
So very interesting case to come. Why you are not ready?
And in this case,
Mr. Tabraj. Why is Mr. Tabraj?
it was
But I saw him yesterday.
today,
Today, why?
some
Because circuit is going on and he is leaving
family.
family. So what can be done? There is a CBI matters. I cannot. So Friday,
Next week, my lord.
next week.
Next
Why?
week will take some time.
It will take some time. How much time?
7 weeks, 7 days, 1 week.
You are saying that it will take some time. That means duration of hearing. Huh?
So it didn't happen, but it came back.
Yeah, 8 matters. So 8 matters should be.
Yes.
8 matters should be. Huh?
Can be heard together, all the FIR, all these revisions are arising on the same.
So you will be assisted by your senior. Who is your senior?
I'm not, but that's a council matter.
So-
So.
So come back on Monday because I was very interested to take up all these matters, age matters. So there are Hitesh or Himesh, Sundarba and Jignesh Kumar. There are 8 matters consecutively. The learned counsels for the parties have prayed for an accommodation. Stop. List the matter on. Have prayed for accommodation as their learned counsels are not available today. ঠিক আছে? So list the matter on Monday. Monday. 8 matters there. Okay.
Right.
Also, I think they stay close.
Yes.
Challenge the order of discharge of the accused.
My lord, before my learned senior starts, Mr. Tulsilal, senior counsel is appearing for the petitioner. He prayed for not today.
Not today.
My lord, you said in one of the appeal, Mr. Kabir is appearing. He is not in station. Fix it on Monday, my lord.
So they will start. We shall hear.
My lord, he
On
cannot-
the side of the victim, another appeal is filed by the Tulsi sir.
Yes.
On the side of the victim, the state also challenge that. Both are, will be lengthy if Monday,
Monday, sir.
so many matters also fixed.
Yes. So many matters are being fixed. Nobody is willing to. Okay, then Tuesday, the learned counsel for the petitioner. Now, you have got
For the petitioner state.
petitioner
First
state,
appeal.
state,
Item number 20.
state item number 23. Jagjit Kumar.
23 and 24 is clubbed together, my lord.
23.
One is by
filed
the state, one is by the state, one by the victim.
দেখুন ওখানে কি লেখা আছে So Jagjit Kumar is
Lordship. CRR 54 by the victim.
by the victim,
And
yes.
24 by the state.
So the learned counsel for the দুটো একই রকম করে দেয়. The learned counsel of the petitioner has sought for an accommodation. List the matter on Tuesday number 8 April. Okay, এটা হলো আর 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 ওখানে ওখানে লিখবেন 24 না কত বললেন ওটা
25.
25টা না 25 রেসপন্ডেন্ট করে দেবেন ঠিক আছে মিস্টার হলো
Yes.
instead of petitioner respondent huh? Only one record oh okay. Which for the other side so you are ready
For last 27 years, we have been paying relating to NSCT
you are paying the
court fee
court fees
in respect of NSCT fee at the date 20. Because we have governed with the court fees regulation and the court fees act.
yes
We are not governed with the West Bengal court fees. Act.
certainly
Now, what the learned court has done, the learned court has fixed the rate at the level court fees or water extent claims, whether it can be done.
so you are appearing I think this
No, I am not, I am supporting the regulation of.
But the lordship on the last day, this honorable court has directed the state to make submission.
Now, what is the
Ultimately,
state?
The state is going to be affected.
Yes. State means administration.
Shatabdu was there.
Satadru is today is not here. To come back on tomorrow. Simple man. Hey, not today, not today. Not today.
Where put the act concerned, what this act is silent. Only accident claims, petitions are application, they are not suits.
Now, in this courts, in the district courts, what the court fees are governed by which statute?
We have our regulation and court fees act. That's it.
So West Bengal court fees.
No, that is not applicable.
Okay,
Because it goes to the union directly, UT government, not to the state government.
that's why I am
We are
saying.
paying.
Yes. Okay, no problem. Not today.
They pay for the responding.
And who is for the petitioner?
My rod is paying. Can this be taken up next month? I was severe pain, even then I asked it matters.
Okay, ঠিক আছে এটা twist করুন The learned counsel for the appellant petitioner has sought for an accommodation, list the matter on 8:30. Sorry, 8:30. Yes.
27, 78 or 25.
Lord, I am seeking extension of time to file opposition on behalf of respondent number 2 and 5.
I am for private testimony.
You are appearing for whom?
Official respondent number 5,
I am for
Deputy Commissioner.
private testimony.
The learned counsel for the official respondent number 5,
2 and 5.
2 and 5 has sought for an accommodation
Private
for the purpose of extending the time for filing affidavit in opposition. Is it correct?
My lord,
Stop. Please, when? Is the matter?
2 weeks time.
Huh?
2 weeks.
In the next circuit.
Liberty is granted to the respondent numbers 2 and 5.
Even I am also for the one of the private respondent, even I will use my approach.
Okay, liberty is granted to the respondents to file their respective affidavit in opposition. When the next circuit will come? Within,
Six.
within
2nd June.
2 weeks. And reply if any within 2 weeks thereafter. Please the matter after the next circuit, but we लेकिन
Obliged, my lord.
Obliged.
My lord, same prior, my lord.
I am appearing for the petitioner in this matter, my lord. Been given to file.
I seek extension of time.
Expired on March 12th, my lord.
then
They have not filed the affidavit in opposition, my lord. My father, pardon your lordship, my petitioner in this matter, the only livelihood is this laboratory, my lord. And the work is still from the April 12th to 2024, my lord.
I'm seeking for very shorter time, which may be given 1 week's time to them to file the opposition, and within 3-4 days I'll file the reply, my lord, so that the matter can be heard. Otherwise, because the next circuit, my lord, is
June, ma'am.
So you are into
Next week.
date of hearing shall be in this circuit.
It will not be possible.
If I
2
give
weeks.
1 week time, then 2 or 3 days, the
Next
The
circuit.
hearing will be done, my lord, but the affidavit should be completed.
hearing will be done in the next circuit.
Next circuit.
Yes.
Yes,
But
that is,
Madam.
why Union of India, why?
But I am appearing for,
Given enough time.
I have filed this, I have given
Enough
this letter.
I am appearing for official respondent, my lord.
I had given this letter.
Not for all the
Seeking
respondents.
the timely compliance, but.
Well, last extension may
He
be.
is not representing all the respondents.
Yes, my lord.
That is the problem. If I allow.
Your lordship, if I may, I appear as for the petitioner as a senior, his senior, your lordship, that we had sought a stay of interim relief, your lordship, that because there are 2 licenses, your lordship, one for the sea area for the particular project in question. A sea area license is required and a land area license is required. The government on one hand gave us the sea area license, and the adjoining land license they refused. My laboratory is in that particular land itself. Then the government is not using that. If they are delaying filing of the opposition, if in the meantime I'm allowed to use the laboratory to do my research work, because that is my only source of livelihood. That is all. During the pendency of their filing the opposition and the matter is heard. On the last occasion, the honorable coordinate bench rejected this prayer of mine just at this stage. Your lordship would see the last order. It has been written in bold at this stage because it was too preliminary. We had just approached the court. That is why it was at that stage not allowed. Now, if they are delaying for so long, now the problem is, your lordship, the practical difficulty, next circuit bench, someone else, they will give another date. It will keep on prolonging, and my lease for the sea area is also for a limited period. That will end, and I have made payments there. So the government entities, both are the same entities. One entity is giving me the license to work on the sea, for the sea area. Another entity of the government, another leg of the government is rejecting the land area, although they all know that I need both of them to continue my project.
But I am seeking.
And there are also meritorious grounds with regards to which I am entitled to the land area license, your lordship, because the policy that on the basis of which they have rejected, that policy is not applicable to individuals, your lord. The 2013 policy, it is only applicable to government bodies. But I am not going into the merits at this stage because they have to file the opposition. But if they are seeking an extension, because next circuit is in June, so till June I will be without any livelihood and without any work, your lordship. It's just they are not utilizing the land also for anything.
It is first extension I am seeking, my lord.
Yes, your lordship, but we are not opposing that also, and they are not utilizing that law. Yes, your lordship.
Here, what can be done? Please, your junior has submitted that give.
Yes, your lordship, and it may be extended, and it may be extended, your lordship. But in the meantime, I may be allowed as an interim relief. I may be allowed to work in my work there in the factory, in my laboratory in the land, and I can utilize the CA. So because my CA license is also there, I am not opposing the extension. Let them take the extension for 1 week or 2 weeks and let them file the opposition. If your lordship does not allow me to work there, what they will do is in the next circuit bench also they will ask another extension, because a different with all due respect, your lordship, someone else will sit, your lordship, another coordinate bench will sit. They will take another extension and they will delay and my license for my C area will lapse after that because I'm not doing any work. On that ground, they lapse that C area license will lapse. I just want, your lordship, let them be given the extension, but I may be allowed to work in the meantime.
No, my lord, that cannot be done.
And they are not utilizing that land. How will they be affected? They are not even, they cannot say also they are utilizing that land.
I cannot. Your junior has said one thing, you are coming with another prayer.
No, lordship, I am supplementing that. I am just supplementing it. I am not.
One more. Why you have not come from Kolkata to here?
Your lordship, I had matters here, but
different types of submission from one point.
No, lordship, I am just supplementing it. I'm just supplementing it.
Please take your breath.
It can be decided only by.
No. I am not here to give you time. No.
One last chance,
maybe Union of India, whatever.
No, I am not for Union of India, my lord.
You have taken so much time. I cannot give you time. I have to hear this matter.
One last
Tomorrow.
chance may be given, my lord.
No, I shall not allow. Come back.
My lord, 1 week at least
Grateful, Your Lordship.
be given.
No, nothing. Come back on tomorrow, whatever it may be. Not today, the learned counsel for the respondent Union of India has sought for an accommodation.
Not Union of India, my lord. I am appearing for official respondent number, Deputy Commissioner.
And who are the other
The answering
respondents?
respondent. Appearing for the answering respondent, effective respondent.
There are other respondents also.
So who are the other
Other
respondents?
respondents, because my lord, we have made representations, they have given me the allotment of the C area.
So
They
they
have
serve a notice.
served them,
Yes.
served them.
Serve a notice and come back on Monday.
It
No, no.
is served, my lord.
The learned counsel for the answering respondent, that means
The DC office.
Deputy Commissioner,
After-
Respondent number,
I have
you do not know anything.
taken not.
The answer
Last thought.
number has sought
Yes.
for an extension. ওটা কি আগে একটা dictation
the
দিয়েছিল?
respondent number 6.
Has sought for an
Respondent number 6.
respondent number 6. Only respondent number 6
Yes, my lord.
has sought for an has paid for extension of time for filing affidavit in opposition.
My lord.
Stop. The learned counsel for the petitioner has raised strong objection. Stop. It appears from the record that several opportunities are given
Only
to
one.
the respondents, including respondent number 1, respondent number 6, but till date, affidavit in opposition has not been filed from the side of.
Lord, this is the first extension I am seeking.
Okay, stop. The learned counsel for the respondent number 6 has submitted that this is for the first time he has sought for an extension.
My lord.
Stop. List the matter on Tuesday. Okay,
My lord.
all the whatever he
My lord.
want to file, you file.
Yes, oblige, my lord.
We shall hear the matter on 8th. Okay.
Oblige, my lord.
Grateful, Your Lordship.
But in this matter,
How is your throat?
still there. I'm taking steps since I argue that, but there will not be much argument so far as this city is concerned. But interim order was refused. Intra-court appeal was filed.
Who is for the
I'm for the official respondents.
official? Have you filed the affidavit in opposition?
My lord.
Do you want to file affidavit in opposition? Have you gone through the?
Yes, my lord. Actually, they have preferred an appeal against the interim order that was rejected by the single bench, my lord.
Yes.
So the appeal is pending.
It was considered by His Lordship Honorable Justice Tapavita Saab, along with sitting.
I should release.
It has to be released.
It has to be.
It has to be released to the next circuit. Because it can't be done. Appeal is still pending.
So-
Appeal is still pending.
Oh,
Some protection, interim protection was granted. And the matter has now been assigned by the Chief Justice to a different bench. It's coming to BC today
Today at 2 p.m.
at 2 p.m.
so what would be the reason for that?
The time to file opposition may kindly be
Yes,
extended. Simplicity order, no.
Whether this order.
There is
has
an order of Justice Vibhasan Day to file opposition.
Yes,
Let that be
that's it.
extended. Simplicity. Nobody.
The affidavit in the
Today,
opposition.
private respondent is not appearing, my lord, in this matter. When
Okay.
private respondent.
For all the respondents, let them
Huh.
use the opposition.
You are for whom?
Official respondents, my lord.
Official respondent. And the learned counsel appearing for the official respondent. Andaman Nicobar
Yes, my lord.
administration. Is present and has submitted that has paid for extension of time to file affidavit in opposition. Stop. Let there be an extension of time for filing affidavit in opposition on behalf of all the respondents. Okay. Please the matter next time.
My lord, item number 30, 31 and 32 are similar matters, my lord. I would be praying for extension of time for filing my opposition, my lord.
Let
The
that be-
first
that-
extension I'll be praying, my
Interim order
lord.
may be extended. There's an
Interim order has to be.
Fine. My lord, that
The learned counsel for the respondents has sought for an extension of time to file affidavit in opposition. Stop. The learned counsel for the petitioner has prayed for extension of interim order that is subsisting. Stop. When the interim order was passed,
By Justice Partha Sarthi Chatterjee.
Date.
Exact date, not. Because, that,
so you please check,
well, I'll just let you.
check and give it to.
My lord, please, my lord. Yeah, order is-
So let the interim order that is subsisting. Interim order dated, huh? Be extended till June
June 30, Worship, till last day of the June 30.
June 30,
Yes,
June 30, 2025, or until further,
which is earlier.
whichever is.
My
Stop. The respondents are given liberty to file. No. The prayer for extension of time to file affidavit in opposition by the respondents is allowed, and they are given liberty to file affidavit in opposition 2 weeks or 4 weeks,
4 weeks, my lord.
4 weeks from date, and reply if any 2 weeks thereafter.
No.
That will list the matter before the.
Oblige, my lord. 30, 31 and 32
It's same
similar
order.
matters, my lord.
Next one.
Similar matters to be passed.
Happy to check.
Here, your lordship, the appellate authority, your lordship, in terms of the regulation, is the lieutenant governor. Now, your lordship, the lieutenant governor is delegate the property to the secretary revenue to dispose of the appeals. But here, secretary revenue has passed an order. Due to oversight, your lordship, though I have made lieutenant governor as a party to the case, but secretary revenue has not been both parties. So I may be permitted to add in, your lordship. I'll serve and come back, your lordship, on Monday.
The learned counsel for the petitioner has sought for an accommodation for correction,
Additionally,
for addition of one of the necessary parties,
secretary revenue.
namely secretary of the union. So liberty is granted.
Yes. With the leave of the court, your lordship, I will add it and I will serve. Sir, welcome.
So liberty is granted, no problem.
Yes.
Okay. Matter appears 8.
Okay. Oblige.
এই শোনো